Okay. Well, good morning, everyone, and thank you for joining us for our 7th annual Construction Industry Legal Power Seminar. We are thrilled to be doing this live for you this morning, and I have a couple of notes to send your way since this is a live presentation today. We'll be taking questions throughout the program, and you can submit them via the chat window on your screen. We will try to get to as many of the questions as we can. I'm not sure that Matt and Jeff, who will be handling the content today, will be able to get to all of those questions. We have 3 presentations for you today. There will be a short 10-minute break between each. We hope you can stay with us throughout the program. It's a fantastic program. We put this together annually at the beginning of the year to try to give you as much insight into what has happened in the past year, but more importantly, what we think is going to happen going forward. I am Dennis Cotter. I'm a partner at the firm here, Smith Amundsen. I'm a co-chair of the Construction Practice Group with my partner, Matt Horn, who you'll be meeting in a second, and he'll handle the first 2 sessions. Matt will talk about OSHA updates for 2022 and tips for managing the inevitable OSHA inspection. He will then transition after a break into the evolving construction industry and how to account for changes in your contracts, really important issue going forward into 2022. And then Jeff Risch, the chair of our Labor and Employment Group, will be with us to close the program out with some great content and information about labor and employment updates, focusing also on recruiting and retaining workers. So before I turn it over to Matt to start the program, I also wanted to note for those of you that are working specific to the construction industry is that our firm has developed and has put together what we call our Smith Amundsen Construction COVID Task Force. And I wanted to note this to you for a couple of reasons. We have our finger on the pulse of the country through national associations, industry associations, legal associations, and what we're sensing out there, and in particular from what we're hearing from the plaintiff bar associations, is that they are not going to let COVID go away after we hopefully get through this and can put the last 2 years behind us. We are seeing that there's a development of an approach, potential case filings, how to go about the COVID case, the third-party case, particularly in construction. On that issue, our firm is handling 2 of the leading cases in Illinois involving third-party injury claims. One is a wrongful death, one is a chronic pulmonary case that are filed against construction contractors. We intend to get the lead case to the appellate court and to the Supreme Court if we can, so we can try to shut this down as quickly as possible. But I just pointed out to you because if you are involved in these issues, if you have a COVID question, if you believe that you may be involved in a third-party COVID claim, I just caution that you may want to look to a firm like ours, candidly, who has put together a team of healthcare professionals, labor and employment professionals, OSHA professionals like my partner Matt, who you're going to meet in a second, experts, consultants, scientists, doctors. That's the kind of team you're going to need in place to be able to defeat these claims when they inevitably come down the road here in the next year or 2. So with that, I will turn it over to my partner Matt Horn, who will start off the program.
Good morning, everyone. Again, my name is Matthew Horn, and I am the co-chair of the Construction Practice Group and chair of the OSHA Practice Group. We got a good presentation for you today. We hope to get through a lot of the relevant updates for 2022 here with you quickly. So without further ado, we will start off with the OSHA updates for 2022 and the tips for managing an OSHA inspection. Again, my name is Matthew Horn. I oversee a team helping clients in all industries across the country with their OSHA issues. As everyone that has dealt with OSHA knows, the goal with an OSHA inspection is to avoid one altogether. But if you have an inspection and you have citations, you need to handle them intelligently. The services that we provide in the OSHA context All right, so with regard to the OSHA services we provide, OSHA compliance counseling, right, before OSHA comes out, OSHA inspection management, evaluating and settling OSHA citations, litigating OSHA citations when a settlement can't be reached, assisting with crisis management, right, serious injury, resolving employee and union complaints, and defending whistleblower complaints. When I became an OSHA attorney, I never thought that my boring practice would be making national headlines, but it has been in the national headlines, as everyone knows, for the last 2 years, but really the last couple months especially. The current state of OSHA, so where are we now, right? Under the George Bush administration is really when I became an OSHA attorney, and there weren't many of us because there weren't that many citations, there weren't that many inspections, and when there were citations, they were for $1,000 and employers were settling them. The Obama administration came in over its 8-year tenure, really ramped up OSHA to be this large, kind of aggressive enforcement agency. And that's really when my practice started to kind of explode. We saw a lot of willful citations, repeat citations, 6-figure fines, all of those things. Under the Trump administration, there was a little bit of a reprieve. It dialed it back a little bit, but OSHA was still out there working and being aggressive and inspecting employers and citing employers. But we saw fewer repeat citations, we saw fewer willful citations, fewer 6-figure fines, and less headlines. So what have we seen under the Biden administration? Well, it's really a continuation and an escalation of what we saw under the Obama administration, right? So more regulation, more inspections, and more citations. Increased fines and repeat and willful citations. So for the 4 years that the Trump administration was in office, I did not see one willful citation. Since the Biden administration took over, I have had 3 of my own clients receive willful citations. So OSHA is back in the business of issuing willful citations. They are back in the business of trying to make headlines and issue press releases, and frankly being extremely aggressive. We've already started to see this, right? I think we're, a year into it, and we're already seeing this. So we see it with the emergency temporary standard, which was blocked, right? So OSHA's trying to churn out and generate new regulations. Politically and headline-motivated citations, right? If you have a fatality, if there's something that makes the news, OSHA's conducting an inspection. OSHA's issuing citations, and they're trying to make them willful. I'm handling, for example, a fire case that was in the news. Nobody was injured, but because it made headlines, OSHA went out there and is conducting inspections. And then again, we're seeing more willful citations. Again, OSHA at this point is going after specific industries, right? I mean, you see a lot, tough time to be a meat processor. OSHA is really going after the meat processing industry and other industries like it. All right, now let's talk about the ETS, right? Oh, hold on. Let's talk about the ETS. So you're probably thinking, Matt, the ETS was blocked. I'm over it. I don't want to hear about it anymore, right? Well, unfortunately, I don't think it's going to be quite that simple. As you know, the Supreme Court blocked OSHA's emergency COVID vaccination and testing standard. And that emergency vaccination and testing standard required employers with 100 or more employees to conduct weekly testing of all unvaccinated employees. That was the main obligation, right? There were other obligations, draft a policy, find out who's been vaccinated, all of these things. But that was really the big one. And I sent out alerts. If you received my alerts, you saw this kind of proceeding through the courts. The first appellate federal court stayed the ETS. It then went to another appellate court because appeals had been filed in all of the appellate courts, so it was consolidated with another appellate court. That court lifted the stay on the ETS. Then it went to the Supreme Court, and the Supreme Court reinstituted the stay of the ETS. So procedurally, that's where it is. The ETS is still out there, but the Supreme Court has stayed OSHA from enforcing and implementing the ETS. And they did that essentially finding that OSHA went beyond its authority in issuing the ETS. Specifically, the court stated, although Congress has indisputably given OSHA the power to regulate occupational dangers, it has not given that agency the power to regulate public health more broadly. Requiring the vaccination of 84 million Americans selected simply because they work for employers with more than 100 employees certainly falls in the latter category. As I'm sure everybody heard, there was a split decision in the Supreme Court on this. And the split was essentially along political lines. So you had the 6 conservative judges on the side of staying the ETS, and you had the 3 more liberal judges that would have allowed the ETS to take effect. Now, and again, reading the news, you don't get the full grasp of the ruling on the ETS, but the court went on to say that OSHA didn't have authority to do what they did, but the court also said, you know who does have authority? It rests with Congress, it rests with the states, and it rests with the local authorities, not OSHA. Do I think that they're just going to drop this and they're just going to walk away from the ETS altogether? No, I don't. I absolutely do not. I think they're going to try and do something, some iteration of it in some form, some way. Now, there's likely not enough votes in Congress to move forward with the ETS nationally. One of the things that the ruling noted is that there was actually a vote in the Senate to essentially block and stop the ETS before the court's ruling. And that vote was in favor of blocking it and ending the ETS. So Congress isn't going to be able to do it. Now, maybe a different story in the blue states, right? The court has said that the states and the local authorities are really the ones vested with this power. For those of us in Illinois, we started seeing, as the Supreme Court was waiting to rule, we started seeing stories that Illinois had adopted a similar rule to the ETS, right? And it was going to be implementing it in Illinois. And so I started getting all of my clients emailing me saying, Matt, if the ETS is blocked federally, is Illinois State going to adopt the ETS and apply it to us? And frankly, I found the stories in the news to be somewhat misleading because they tried to indicate, or they indicated in the stories, that they did apply to all employers in Illinois, but they don't. So that rule that Illinois adopted applied only to public workers, and notably, Pritzker said that they would adhere to the Supreme Court's ruling with regard to the Illinois rule. So it sounds like the Illinois rule mirroring the ETS will even be going away for public employees. Now, the court blocked the ETS, noting it was a vaccine mandate, right? And so then part of that was they also said it arbitrarily applied to larger employers, right? Because the rule only applied to employers with 100 or more employees. The liberal section of the court disagreed, noting it wasn't a mandate because there was a testing and masking option, right? So the liberal side said, you don't have to mandate that your employees get vaccinated, but if they don't get vaccinated, they have to wear masks and they have to test weekly, right? So what do I think's going to happen going forward? I could see OSHA attempting to issue a new emergency temporary standard and not including the soft vaccine mandate or limiting it to larger employers, right? So when I first read the ETS, what I found to be most inappropriate legally was the fact that it arbitrarily only applied to larger employers, right? So I thought that's kind of where the court was going to go with it. And that is one of the things that they found. So again, as soon as the Supreme Court issued its opinion, the Department of Labor came out and said, we disagree with the court's opinion. We're going to evaluate our options moving forward. And so I think that they're going to try and do something else. So you're going to have to keep this on your radar. What could they do? They could codify some of the guidance that I'll be talking about in the following slides. And they could codify certain testing obligations, right? So what the majority really took exception with the ETS was the vaccine mandate idea. So they could, OSHA could go away from that and try and issue another ETS. Now, so where are we at now? The ETS is blocked, right? There may be another version of it coming out from OSHA. There may be, in some of the blue states, the states trying to issue their own rules. You may have counties trying to issue their own rules. I know that's happening a lot, counties and cities in California. Where are we at now? What do you need to do? And, you know, the unfortunate reality is we're not in a much different position than we were a year ago on this. I gave substantially similar advice at this same presentation last year because OSHA's COVID guidance really hasn't changed. And, you know, frankly, I thought that we were heading in the right direction and they would be pulling all of this stuff back. And then, you know, over the holidays, we saw Omicron and all of those things. And so I think this has become an emphasis again. I am seeing, so after a hiatus, you know, in 2020, I handled 50 COVID inspections. There were a ton of them. That's all OSHA was doing. And then in 2021, those started to slow down. And even in the summer and the fall, I didn't have any ongoing COVID inspections, but they have started up again. And I have some COVID fatalities that happened recently. So again, this stuff is not going away in the short term. So you need to know what you need to do to comply with OSHA's expectation at this point. So OSHA is recommending that all employers adopt a formal COVID-19 prevention plan. If you don't have a COVID-19 prevention plan, put one together. It can be as simple as taking your email alerts and your postings and all of those things and putting them in a binder, but have something together so if OSHA comes knocking, you can say, here's my COVID-19 prevention plan, all right? Now, what should be in the plan? Conduct a hazard assessment related to COVID-19 exposure, right? The potential for COVID exposure is different across industries. It's different across job types within the same industry. So that's what OSHA wants to see. They want to see that you're thinking about individual workers, individual job types, what the exposure is, and how to limit it. Identify control measures to limit the spread of COVID. Distancing, masks, barriers, work from home, staggered shifts, right? A lot of people are doing this. Most people are, right? Just put it into a COVID plan. Put it into writing. Put it into one place. Again, and I say this to my clients all the time, compliance is not necessarily the same thing as safety, right? So I say, put it into a COVID plan. And my clients say, well, we're already doing all of these things. And the answer is, that's great, but that's not necessarily compliance, right? So two separate things. Be safe, but also be compliant. Adopt policies that encourage sick workers to stay home and not come into work. Communicate and train employees on the policies and procedures, and then implement protections from retaliation for workers who raise COVID-19 related concerns. So this is what OSHA is saying that they want to see. If you do this and somebody calls to complain about your COVID measures, or you have an employee that's admitted inpatient or that dies and you have to report it to OSHA, if you do these things, if you have this plan, you'll likely be in good shape. You won't be cited. So policies for distancing, right, stagger shifts, reduce capacity, implement engineering controls, physical barriers, plexiglass, ventilation, PPE, personal protective equipment, implement administrative controls, face masks, right? Face masks has got to be one of the most confusing. It's hard for me to even figure out what the rule is regarding face masks at this point. But in short, if employees are not distanced and unvaccinated, then they need to wear masks based on state and local guidance, right? I had a lot of questions regarding masks because, OSHA and the CDC previously came out and said if you're vaccinated, you don't have to wear a mask, and then if you're unvaccinated, you do. And then in the ETS that was blocked, they again indicated that only unvaccinated people needed to wear masks. So there has been so much conflicting advice on masks. But generally, if your employees are not distanced and not vaccinated, and the state and local guidance requires masks, you should have them wear them. Routine cleaning and sanitizing. Return to work and quarantine. This has been another one. This changes all the time. And it kind of changes under the cover at night. I can't tell you how many times I've had to go to the CDC's website to see what the current rule was on returning to work after testing positive for COVID and quarantining. So, but briefly, if you test positive for COVID, you can return to work 5 days after the positive test, assuming you have no fever, and you have to wear a mask for another 5 days, right? We heard about the shortened 5-day period from the CDC a couple weeks ago. If exposed to someone with COVID, right? You're exposed to COVID, but you don't have it. If you're vaccinated, you can go to work, wear a mask for 10 days. If you're unvaccinated, you're supposed to isolate for 5 days and then wear a mask for 5 additional days. National emphasis program. So again, everyone sees that this ETS is blocked, that they don't have to go through and test all of their unvaccinated employees, that they don't have to do this thing, and they feel relieved, right? We're done. We're out of the woods. Well, unfortunately, we're not out of the woods. OSHA has said, and even in their statement after the ETS was blocked by the Supreme Court, OSHA came out and said, well, we're going to continue enforcing all of our COVID guidance and COVID obligations, and we're going to do it through our national emphasis program. So OSHA launched a national emphasis program, I think it was last year, focusing enforcement efforts on industries and employers most impacted by COVID. It put a primary emphasis on inspecting workplaces where there have been COVID-19 related fatalities, injuries, outbreaks, and employee complaints. All right. So again, I can't tell you how many COVID inspections I've dealt with in the last 2 years. It's a staggering amount. Many of them related to fatalities. Many of them related to employee complaints, right? So if you have a difficult employee and they want to make your life difficult, the easiest thing for them to do is to call OSHA and to say that you are not following COVID measures. As to the National Emphasis Program, so the program requires OSHA to compile a list of employers to inspect based on industry and employer 300A data. All right, so OSHA's looking at that 300A data that you're submitting, and if they see that your numbers are inflated over the last year or two compared to what they were before, you're on their radar. So this includes employers in healthcare, meat processing, food handling and processing, warehousing and storage, agriculture, construction, and manufacturing, with elevated illness rates according to the employer's individual 300A data. So again, I got some clients after the fact, after they had all these COVID outbreaks, and after they had put all of these COVID cases on their 300 logs. So for 2019 on their 300 log, let's say they had 3 recordable instances. And this was big in healthcare. And then in 2020 and 21, they had 75 recordable events because when somebody contracted COVID, they put it on their 300A. Well, guess what? OSHA's going to look at that. They're going to look at that data, and if they see that discrepancy, they're going to put you on the list for an inspection. There's some good news. OSHA only has 6 months after the violation to issue citations. So if you had a massive COVID outbreak and you have 25 cases on your recordable log from that, but it's from 8 months ago, if OSHA comes out, they can't cite you for any of that. OSHA enforcement. All right. So where is OSHA at now? Not Washington OSHA, but your local OSHA office, right? Your local area office. They're overwhelmed with calls and complaints regarding COVID, but it's getting back to normal. It's funny, I used to be able to call an OSHA area office and I would be able to talk directly with an assistant, and they would then connect me directly with the area director. And now, if any of you have called an OSHA office, it's like a 10-minute message essentially about COVID. And then you have to dial all of these things to get to people. And then you go to a voicemail box, and then somebody calls you back. So they're just inundated. So they had to set up these procedures basically to be able to wade through the COVID complaints. At the end of 2021, as COVID kind of subsided and we got back to normal, and I'm talking about summer and fall, OSHA was doing primarily in-person inspections again, construction projects, warehouses, things like that. Now it's kind of gone back to COVID. For most COVID cases, OSHA is generally allowing employers to self-report, assuming there's no fatality, assuming there's no death, assuming there's no massive outbreak or inpatient hospitalization, or it hasn't made the news. And why are they kind of limiting this to COVID fatalities? Because there's a lot of COVID fatality inspections. Why? Because for the first time, employees passing away outside of work is now the employer's problem. I would guess I've probably handled 25 COVID fatality inspections since COVID hit. Not one of those fatalities occurred at work, right? The employee didn't die at work. The employees, for the most part, died at home. Some died in the hospital. And, so with COVID, it's kind of taken the event needs to happen at the workplace element out of it, right? If people were dying, if people were coming into the hospital with COVID and the county was finding out about it, the county was telling OSHA, OSHA was looking into the person's employer and then conducting an inspection. So that's happening. Now, what happens with an OSHA inspection? The vast majority of the OSHA inspections I've dealt with pertaining to COVID, there have been no citations issued. All right? If the employer can prove that it followed CDC and OSHA guidance, then there's no citations. In my experience, is OSHA isn't requiring strict 100% compliance with their guidance. They're looking to see if there was a good faith effort. And from my discussions with the boots on the ground, so the area directors and the inspectors themselves, they're as exhausted with COVID as we all are. They're not looking to hammer people relating to COVID unless they're not making a good faith effort to protect their employees. Now, I have seen some citations. So if you can't establish that you were taking good faith efforts to comply with their guidance, or you have people who are saying, I'm not complying and refusing to comply, then citations follow along with press releases, negative attention, and media claims. There used to be kind of this threshold for press releases that there had to be fines over $100,000 or more. And I've seen OSHA issuing press releases for $5,000 inspections with one citation under a general duty clause pertaining to a COVID violation. So again, OSHA has become a somewhat political football at this point, a political talking point. And, they're using, the Biden administration is going to try and use OSHA's efforts as a talking point. Since OSHA currently has no COVID standards, again, they usually issue the citations under the general duty clause. But also sometimes recording and reporting, PPE, and respiratory protection. OSHA recording. This is the one probably that I've been getting the most questions about and frankly dealing with the most citations concerning. So OSHA is requiring employers to record and report employee COVID-19 cases in certain circumstances on their 300 logs, and if necessary to report it to them. So what are the criteria? The employee has a confirmed case of COVID, the case is work-related, and the case involves one or more of the general recording or reporting criteria, namely medical treatment beyond first aid, days away from work, hospitalization, or death. This is the question that I've been getting from people for the last 2 years. What is work-related, right? When do I have to record my employees' COVID cases on my 300 log? Well, in order for a case to be work-related, the employee has to be infected at work. It's not enough that he or she contracts it outside of work and displays symptoms at work. Okay, then they say to me, Matt, how do I determine where they contracted COVID-19? Well, as we know, it's not easy. But OSHA has provided guidance, and the guidance says it's recordable if the employer makes a reasonable determination that the case is work-related. How does the employer make that determination, right? Through discussions with the employee, reviewing any objective evidence available. So I spent the vast majority of 2020, the years are running together at this point, 2020, helping my clients with these reasonable determination investigations, right? So look at the facility layout, evaluating exposure, timeframes, texts and emails. And then, if you want, you can have a questionnaire that should be filled out by employees with COVID, inquiring as to their exposure to COVID in and outside of the workplace, right? So just for example, I had a client operated a big warehouse, right? And they had a COVID-19 fatality. And just before that COVID-19 fatality, they had another employee that had COVID-19. And so we had to look to see if that other employee gave COVID-19 to the employee that ultimately died, because we only knew of those 2 cases, right? So what did we do? We looked at the first employee who was infected, where he worked, what his job duties were, whether he would have crossed paths with this other employee. And so, that's kind of the analysis that you needed to do, is you needed to connect the dots and say, okay, person A had it at this point, and person B got it here, and they worked here, but they never interacted, or they did interact. And so, that's the analysis that you need to do to make that determination. Now, why is this important? You're saying, Matt, I got so many COVID-19 cases, I can't do this anymore. I'm not recording any of them. I've heard a lot of this, and I know people aren't. The concern with that, and what I saw, is then employees were complaining to OSHA. Or then through the county health department, OSHA found out about an outbreak or about an employee dying. And then OSHA came in and did an inspection, and then OSHA would cite the employer for not properly recording or reporting OSHA COVID-19 cases. So that's practically how it's worked, and I've seen that. So just be careful when you're doing these things, when you're determining what to include and, more importantly, what not to include on your OSHA 300 log. What I'm telling my clients is be aggressive, right? If there's no other explanation than this person got it at work, put it on your 300 log. If there's some other reasonable explanation, don't. COVID-19 retaliation claims, protected activity. So protected activity by employees can include calling OSHA, refusing to work due to safety COVID concerns, reporting alleged unsafe work environments to management, complaining about alleged work-related injury or illness, or testifying in internal investigation. So again, over the last 2 years, we have seen employees, disgruntled employees, really using COVID kind of as a sword, calling OSHA, making complaints to management, and doing all of these things, frankly, because they're disgruntled or they're pursuing some sort of whistleblower claim, all of these things. So just be careful when it comes to this protected activity. Do not terminate an employee due to raising COVID concerns or issues. Rather, focus on the employee's behavior and conduct, right? So if you have somebody who's clearly disgruntled and they're just you can tell that they're just being difficult raising COVID-19 concerns and you want to terminate them, focus on their other behavior and conduct. We saw this a lot in 2020, employees just refusing to come in, saying, I'm not coming into work because of COVID-19. My employers were doing all the right things, masks, sanitizing, distancing, plexiglass, barriers. Refusal to work solely due to the fear, particularly unsubstantiated one, can be considered job abandonment. Now, tips for managing an OSHA inspection. So that ends the segment on what's happening now with OSHA, the updates for 2022, what you need to do. Now I'm going to talk about tips for managing an OSHA inspection generally. And this will include some new information, but it'll serve as an excellent refresher as to what to do if OSHA comes knocking. Because again, at this juncture, I think OSHA inspections, especially for construction, people in the construction industry, it's inevitable. One thing to note, so we've got new fines. A couple years ago, OSHA said we're going to adjust our fine schedule every year based on inflation and cost of living adjustments. So they just went up, again, a couple days ago. So the max fine for a serious citation at this point is $14,502. And then for willful and repeat citations, the max fine is $142,502. All right. Failure to abate and other than serious citations carry fines of $14,502. Now, these numbers are concerning, right? I mean, $142,502 for a willful or repeat citation is crazy. Now think about the fact that whenever I see a willful or repeat citation issued, there's usually more than one of them, right? So, once you get a willful or a repeat, you're usually talking about a potential max fine of around the $300,000 mark. Now, what's even more concerning? So in the budget reconciliation bill that's kind of stalled out in the House of Representatives, this is the Build Better Back that we keep reading about. In that bill, they are seeking to increase OSHA fines 5 times. So the proposal in that bill in the House of Representatives would raise the max fine for a serious citation to $70,000 and for a willful and a repeat citation to $700,000. And the justification for this was OSHA was saying that employers were willfully violating the COVID-19 guidance because the threat of an OSHA citation wasn't great enough, didn't justify them expending the resources on implementing the necessary COVID-19 protections, right? So that's the justification. And fortunately, it looks like that budget reconciliation bill is stalled out and is not moving forward. But if it does move forward, just be aware that this is in there, and you could be looking at a 5-fold increase in OSHA citation fines in the very near future. Reporting requirements. All right, this new rule is, I can't even remember how old, 5 or 7 years old. But very few people seem to know about it in the industry. So the reporting requirements for OSHA. If there's a fatality that occurs within 30 days of a work-related incident, it needs to be reported to the local OSHA office within 8 hours. All right? Here's where the new rule come in. So the old rule was if you had 3 employees admitted inpatient stemming from any one incident, you had to report that to OSHA, right? And that never happened. I mean, you're talking about building collapse, fire, things like that, where 3 or more employees is hospitalized at one time. They changed the rule. It only required an amputation, so even the end of a finger, loss of an eye, or the hospitalization, one employee, of an employee within 24 hours of the incident. Again, hospitalization means admitted inpatient. So if the employee is treated in the ER, don't have to report it. If the employee is treated in the ER, released, and then has outpatient surgery, don't need to report it. If the employee is kept overnight in the ER, you don't need to report it. So there are many exceptions within these general rules that you should be aware of. One of the strongest benefits that I provide my clients is when they have an injury, when the person receives medical treatment, they call me and they say, Matt, do I need to report this? Because there are many exceptions written into this rule that employers, even if they're aware of the rule generally, are not aware of the exceptions. Employers must report the incident within 24 hours of learning about the triggering event, and I am seeing many, many citations issued for employers not adhering to this. It's probably the most commonly issued citation I'm seeing at this point. And this is resulting in more inspections than ever. Why? Because every time somebody has an employee hospitalized, they have to report it to OSHA. So the inspection process, what does the inspection process entail? The opening conference, the walk around, the employee interviews, document requests, the closing conference, citations, the informal settlement conference, and then contesting citations if necessary. I'm going to just go through these quickly and give you some quick tips on some of these things. So the opening conference, this is when the OSHA inspector shows up at the project, the gate, the front door, whatever, says, I'm here to conduct an OSHA inspection. Company representatives should absolutely attend the opening conference, right? Do not allow the inspection to start until the appropriate people are on site, whether that's your safety director or your owner or the project manager or your attorney. Make sure that all of them are there before the inspection starts, okay? And I'll talk about how to make that happen. During the opening conference, the inspection officer must give the reason for the inspection. It's plain view, meaning they saw somebody doing something unsafe, there was an accident reported to them or they found out about it through some other means, a complaint, and then a scheduled inspection. If there was a complaint, request a copy of it. So it's essential that you find out the purpose for the inspection. Why? Because the purpose of the inspection, the basis for the inspection, dictates the scope of the inspection. All right? So at the opening conference, make sure everyone's there. Make sure you find out the basis for the inspection. Consent in the OSHA inspection. You say to me, Matt, how do I get the OSHA inspection officer to wait until everyone's on site? They might not be able to get there for a couple hours. They might not be able to get there till the next day or the next week. This is how you do it. Consent. So the employer has a right to request a warrant. All OSHA inspections are voluntary unless OSHA has a warrant. All right? And OSHA never shows up, well, not never, 99% of the time does not show up to conduct an inspection with a warrant. All right? So know that you allowing them to conduct their inspection is voluntary. Unless they have a warrant, it's voluntary. So you have the right to dictate the terms of the inspection. You can say, listen, I need everyone to be here before we can conduct this inspection. Most of the inspectors will say, okay, how long do you need? I'll give you a reasonable time. Some of the bad ones will say, no, I'm coming in now. At which point you have to say, do you have a warrant? If you don't have a warrant, then you're going to have to coordinate it with me or get a warrant. All right? Usually I will ask OSHA to wait at least a couple hours, sometimes days, sometimes a week to come back and conduct an inspection. The reality is they have very little choice. They have no choice unless they have a warrant. You say to me, Matt, what about if they get a warrant? Well, if they get a warrant, first off, it takes sometimes weeks, at the least a couple days. And in the warrant, it severely limits what OSHA can inspect as part of the inspection. So OSHA doesn't like getting warrants. So that's how you buy time. That's how you get everybody there. All right? But if somebody consents, if you let the OSHA inspector in, they will infer implied consent. So if you don't specifically object and say, hold on, I need everybody here before this starts, and you let them in, and they start doing their inspection, you've impliedly consented. The walk around. All right, so everybody's there. OSHA's told you the purpose for the inspection. Now you have the walk around. So never allow the OSHA officer to walk the worksite unattended. Company and union representatives have the right to accompany the officer. Limit the walk around to only the relevant areas. Take parallel videos, photos, samples, and notes. All right. Now, what does limit the walk around to only the relevant areas mean? When you ask OSHA the basis for the citation, they have to tell you, right? So if they say, we received a complaint that you are not covering the end of rebar on the second floor of this project, all right? At that point, you know that the scope of the inspection is limited to them looking at the rebar on the second floor. So that's where you take them. And as part of the opening conference, you get the inspector to agree to that scope. You say, okay, so I'm going to let you go up on the second floor, and I'm going to let you take a look at the rebar on the second floor so you can see that it's capped. So that's what you have to do. You have to limit it to expressly what they're there to look at. Somebody falls off a ladder, right? Okay, go take a look at the ladder. Here's the ladder, and that's it. That's all you're entitled to. So just make sure that you limit the scope of the inspection. Because OSHA wants to come on site and they want to walk around unencumbered. They want to go wherever they want. They want to see the whole project, the whole plant, the whole facility. And when you allow them to do that, that's when you get into trouble. Employee interviews. Just like the walk around, just like the OSHA coming onto your private property, employee interviews are entirely voluntary unless OSHA has a subpoena for them, and they rarely ever get subpoenas. Just know that if somebody doesn't want to be interviewed, a lot of times with fatality inspections, OSHA wants to interview the people that were there right away. And I always say, listen, we need to take some time. We need to slow it down. They're upset. They're not going to be thinking correctly. We need to reschedule these for a week or 2 weeks or 3 weeks or 4 weeks. And the reality, again, is they have no choice. Any supervisory employee can be interviewed, any foreman, crew leader, lead man, etc. Applies even if the person is union. Anyone can be present during management interviews. So the owner of the company, the attorney, the project manager, they can all sit in on the other supervisor's interviews. Why do I recommend that? Because then everyone knows what everybody's saying. Union and hourly employees may be interviewed privately or with a steward or whoever else they want there, including a translator, right? Again, these are entirely voluntary. OSHA wants you to think that they have the right to just pull people and interview them individually, but if that person being interviewed wants somebody else there, they're absolutely entitled to it. What is said becomes evidence for purposes of issuing citations. Know your rights, right? Have the right not to be recorded or sign statements. Read a statement before signing. One of the things that drives me crazy with OSHA is they have employees sign off on statements that the OSHA inspector has drafted for them. So the OSHA inspector will interview an employee, they'll summarize that discussion in their own handwriting, then they'll ask the employee to sign it. A lot of employees just sign it, even if they can't read the handwriting, even if they haven't read it. So, those are the types of things that you need to control and make sure don't happen. OSHA document requests. So make sure that OSHA requests its documents in writing via email or otherwise to one source. Just like with the scope of the inspection that we discussed, if they request documents that are outside the scope of the inspection, right? So let's say the inspection pertains to a broken ladder, and they request your HAZCOM program, and they request your silica program, and they request all these things. The answer is no. It's not relevant to the inspection. The closing conference. So most OSHA inspections usually take 3 to 6 months. OSHA has 6 months to issue any citations stemming from an inspection. Usually they use at least a couple months of that. Then they say, all right, we've finished our inspection. We want to have a discussion with you about the citations. This is what they call the closing conference. Primarily a listening exercise, but it allows you to find out what the inspection findings were, what citations they intend to issue. The issuance of citations. So after the closing conference, OSHA sends out the citations. Citations must be received within 6 months of the inspection or the incident. So if the inspection starts a month after the employee complaint or the employee injury, then That's what triggers the 6-month time frame, the actual alleged violation itself. All right, so know that. Citations will reference the standards violated, the proposed penalties, etc. Act on citations immediately. How can you respond? You can pay the citation in full, and I don't advise this ever. You can have an informal conference with the area director, which I always suggest. You can submit a notice of contest, and then you can go to formal settlement and hearing. So after the citation, the informal conference with an OSHA area director must occur within the 15 working day period. So 3 weeks. 3 weeks after receiving the citations, you have to hold the informal conference, and you have to either settle the citations or contest the citations. If you don't do either, they become a final order, and they're enforceable essentially in court against you as a judgment. This deadline is not extended under any circumstances, right? And just scheduling the informal conference within 15 working days. So calling to schedule it within that 15 days isn't enough. You need to actually hold it. Preparing for the informal conference. So the greatest obstacle to a settlement in an OSHA case is an unrealistic view and position by one or both of the parties, right? So my clients often come to me, and there's so much uncertainty as to what citations are valid or not. Usually they kind of have a sense this one's valid and this one isn't, but they don't know how to articulate it clearly, and they're not confident in their position for the most part. So to eliminate the uncertainty, I tell all my clients, and I of course help them with this, evaluate and analyze the citations to identify the merits, right? Prepare a memorandum evaluating each citation and the defenses to the citation, and then formulate an aggressive settlement position accounting for the merits, right? So if OSHA issues 5 citations and 4 of them are clearly invalid, going in and accepting a fine reduction and all 5 citations really isn't a great outcome, right? You should go in on the merits and say these 4 are invalid. They need to be vacated, but we will accept this one that is valid, right? So go in, don't just go in and beg. Don't just go in and ask for some obscure settlement without a basis. Go in and say, these citations are invalid, here's why, but we'll accept the valid ones. Typical defenses, conduct doesn't violate the standard. This is the most common one, right? OSHA improperly issues a citation. I see it all the time. In almost every inspection that I'm involved in, OSHA issues at least one citation improperly that didn't violate the standard. Lack of employer knowledge, no employee exposure. So again, I had a client on the rebar case. They were building a high-rise, and OSHA came out, did an inspection, and they took a picture on a floor where no employees were of exposed rebar. And they cited us for it. And we said, well, there were no employees working on that floor. When they go and work on the floor, they cover the rebar, right? So, that's the kind of stuff that OSHA will just cite you for a violation even if there's no employees exposed to it. The employee misconduct defense, this one, the employee misconduct defense is so misunderstood. It's very difficult to achieve. This is a lengthy discussion in and of itself. Infeasibility, impossibility, compliance presents a greater hazard, duplicative citations, and the citations not properly classified. These are all defenses that I use every day. Here's just an example of what my typical OSHA citation memorandum looks like, just so you can see it. It includes the language of the standard actually cited, the alleged hazard outlined in the citation, and then the legal explanation of the standard cited and the defenses. Right? So comparing the actual language of the standard with what OSHA claims was the violation usually will give you a pretty good idea as to whether the citation's valid or not. The informal conference. OSHA encourages it, and it should always be pursued. I think you should hold it just to make a good impression for future inspections. It's a potential means for resolution without litigation. It allows the employer to gain an understanding of OSHA's evidence and expectations. There can be a free discovery and exchange of evidence if the area director will play ball, and it will level the playing field. Again, don't beg or argue irrelevant issues. Evaluate the citations, discuss the facts, and reach a settlement on the merits. Settlement techniques. So again, demonstrate valid defenses, group-related citations, reduce classifications, so move repeats and willfuls to serious, seriouses to other than serious. Accept citations under standards with less future exposure. So if my clients get a guarding or a lockout, tagout, or a fall protection citation, something where they have a lot of exposure, I try and get it issued under another standard, assuming that it's valid. Trade abatement for classifications. To contest or not to contest. One of the good things about contesting is initially it's very inexpensive. All you have to do is send a letter saying, I'm contesting it. And then that buys you about 60 days of inactivity from OSHA. Then you get to a point where you or your attorney are negotiating with an attorney for the Department of Labor who looks at the case a little bit different than the area director. They look at it under the lens of, can I win this case, right? So, unless OSHA makes a good offer at the informal conference, I almost always contest it just to buy time, just to have discussions with another person from OSHA and kind of, slow things down a little bit. But again, a lot of people are contesting citations at this point. And these are the various things you should consider when looking at that. The contest process, as I discussed, when in doubt, contest it. I contest 50% of the cases at this point. 60 to 90 days to discuss settlement. If you can't reach settlement at that point, one of the other good things about contesting is you can get the inspection file. And the inspection file will provide you everything that OSHA has, so you can see what their evidence is. It helps in the case. It also helps my clients a lot of times in their work and the safety pertaining to their work. Small-scale litigation, they usually settle. So these cases usually settle, and OSHA's offer rarely gets worse. It usually gets better as the litigation goes on. So, other than attorney's fees and costs, assuming you have an attorney because you can contest yourself, there's really no downside to contesting. Okay, that is the presentation about 3 minutes early. I've got a number of questions here that I will wade through now. Let's see. All right. Is a COVID case at work a reportable incident on the 300 logs if the employee has days off work due to quarantine? If the case was contracted at work and they are off because of quarantine, the answer is yes. Is this webinar being sent to attendees for replay? Yes. What types of businesses are having COVID fatalities? All of them. Because, what I saw in my COVID fatality inspections is the people that were dying were over 60 and have health conditions, right? Severe health conditions. So the deaths were happening across the spectrum. People in offices, people in construction, people in warehousing. I saw no real difference. I would say there were more deaths with my healthcare clients, right? Nurses and things like that who are older with pre-existing conditions. But I dealt with fatalities in every industry. If there is a COVID death and both spouses or partners work, how can one employer or the other be blamed for a COVID death? Especially right now when everyone seems to be contracting COVID. This seems like a very hard thing to prove and a waste of their time. Well, they'll tell you it's definitely not a waste of their time. This is going to be a political talking point in the 2022 and the 2024 elections. You'll be hearing a lot about what the Biden administration has done to protect employees, what OSHA has done to protect employees from COVID, the inspections they've conducted, the citations they've issued. But as to your real question, how do you determine where the employee caught it? Again, if you do the investigation that you're required to do, and there's no evidence, you can't say essentially definitively that they contracted it at work, that's the only option, then you make a determination that it wasn't contracted at work and you don't include it in your 300 logs and you don't report it to OSHA. What if OSHA fails to hold the closing conference? Is the citation null and void? OSHA is supposed to hold a closing conference. If they don't, the citations are not null and void, but you should certainly bring it up with the area director. And if it's part of a larger pattern of the inspector not doing what they're supposed to do, it can be a defense to citations. So they're supposed to do it, but if they don't do it, no, it's not a get out of jail free card. Let's see. I think that's about it. I think those are all the questions. Okay. All right. Well, my timing is perfect. Let's take a quick break. Thank you.